Hello, I'm John Henkes, president of Wisconsin Public Affairs Network. For 12 years now, Wisconsin has been providing free television and internet access to the proceedings of our Wisconsin State Supreme Court. We could not do this, of course, without the support of our Supreme Court justices, who, like Wisconsin believe that transparency in our judicial system is vital to public trust and understanding. Wisconsin is the nation's first independent, non-government funded state capitol broadcast network. We are a small nonprofit with continued need of charitable support. Among those who benefit most by the live coverage and thousands of hours of archived state capitol proceedings is the Wisconsin legal community. Attorneys and their staffs rely on Wisconsin for live coverage, archival research, courtroom preparation, analysis of legislative intent, and the training of young attorneys, and much more. And so we appeal to you, Wisconsin law firms and lawyers. Please help us to continue this valued service. This year, we will launch a campaign within the Wisconsin legal community to help raise funds needed to continue the work of Wisconsin We will be reaching out across the state to law firms large, medium, and small, asking you to join together in supporting Wisconsin coverage of state proceedings. Within that mix, we are looking for a few champions who will help us to lead this effort within your profession, and we will generously recognize you for your support. Please welcome the conversation when we call, and thank you in advance for your participation.
This program is made possible by the support of Delta Dental, Quick Trip, Marshfield Clinic Health System, Wisconsin Counties Association, Wisconsin Hospital Association. Watch Wisconsin on Spectrum Channels 995 and 363 and at wisi.org.
All rise. Hear ye, hear ye, hear ye. The Supreme Court of the state of Wisconsin is now in session. Your silence is commanded. Where am I going? To your chair.
Good. I know which my chair is. Well, it's good being here.
Please be seated.
Thank you. Before we begin today, I note that we have some students who are going to be observing this argument. I think most of them are upstairs in a room above because we have a full house with others here today. But we do welcome the Milton Home School Group, Waukesha County Home School Group, and Dodgeville High School, and they are all in room 412 upstairs, so we really have lots of interest. When we are finished, Justice Kelly, I believe, will talk to some of the homeschool groups, and I may help as well if he needs a little more assistance, but that'll be after you all are finished. So now I will call our case for the day, League of Women Voters versus Governor Evers, Tony Evers. Counsel, are you prepared to begin? Please do.
Misha Tsaitlin for the Wisconsin Legislature. For 4 decades, since 1971, the legislature has scheduled the entire biennial period with floor periods, committee periods, with the option of turning a committee period into a floor period using a previously uncontroversial, entirely banal internal legislative procedure. Nothing the legislature did in the December 2018 session departed from this well-established practice in any respect. This court should reject this effort to interject the courts into matters of internal legislative procedure. As I explained in my briefing, that we have 3 independently sufficient reasons why plaintiff's case fails. I would like to structure my presentation around those 3 reasons. First and primarily, nothing the legislature did in December 2018 violated the Wisconsin Constitution, which should end this case. The relevant constitutional provision here is Article 4, Section 11, which provides in relevant part that the legislature shall meet at the seat of government at such time as provided by law. That, we would submit, raises 2 issues. 1, did the legislature meet at such time as provided by law at Madison, Wisconsin? And when did that meeting end? Now, the parties in this case disagree on many things, but we all agree that the legislature met as provided by law in January 2017. The question then is whether and when that meeting ended. We would submit that this court's decisions in Damon and Thompson answers that question. In both cases, this court distinguished between the meeting and recesses of the houses of the legislature and the meeting and final adjournment of the legislature itself. In Damon, this court used the phrase cease to exist to mark the end of the legislature. In Thompson, the court used the phrase dissolve itself. It said the 76th legislature had not dissolved itself. And Thompson is particularly telling, I would submit, because in Thompson the question was the legislature in session during a recess of the houses? And this court held in unambiguous terms that even though the houses of the legislature were in recess, the legislature itself was still in session because the 76th legislature, the 2-year legislature, had not dissolved itself. Applying those principles straightforwardly to this case, the 103rd legislature, the 2017-28 legislature, had not dissolved itself by December 2018, which should be the end of this case. Now, my friend's submission that the 103rd legislature dissolved itself on March 22nd, 2018 is clearly wrong. What happened on March 22nd is that the houses stood adjourned pursuant to JR1. That is the recesses of the houses of those legislature, the recesses that this court talked about in Damon and Thompson. The legislature made clear that it was not dissolving itself, that it was not ceasing to exist. It was standing adjourned, using the exact same terminology that it had used at the end of every floor period throughout the biennial session.
Counsel, you started your comments with the last 4 decades. Well, I haven't been around here for 4 decades, unlike some, but I have been around for a couple of decades. And there are times during the year when things are all scurry, because we all know that the legislative session is going to end at a certain date, and then all bills that were not passed in identical fashion by both houses will have expired. We get that message periodically. I pulled out something from 2012, that on March 16th, 2012. So how can you square that with the idea that for 4 decades it's been running the way that you advance?
Well, Your Honor, certainly at the end of the last rescheduled floor period, as a matter of internal legislative procedure, the houses of the legislature do adversely dispose of all of the bills. However, under Senate Rule 93, which we cited in our reply brief, the legislature has the authority to bring back any of those bills if it comes back into a non-prescheduled floor period, which is titled an extraordinary session, but is nothing more than a non-prescheduled floor period. So the legislature does anticipate that its business is probably going to be at an end if no new needs arise. But sometimes new needs do arise. You know, sometimes the Milwaukee Bucks threaten to leave town, and the legislature has got to come back in and fund and authorize an arena so the Milwaukee Bucks don't move out of state, or some other things may occur. And the legislature, that's exactly why the legislature does not dissolve itself at the end of the last prescheduled floor period.
I want to take you to the language, and I don't mean to interrupt. Were you finished?
Yes, Your Honor.
All right. So looking at the language, because you did start with that, and I think that we should all focus on text, we're looking at the Constitution, which talks about the legislature shall meet at such time as shall be provided by law, unless convened by the governor in special session. Now, I think you'd agree that a joint resolution is not a law because it hasn't passed both houses and been signed by the governor, correct?
With regard to this particular provision, yes, it is not.
So the only law we have to look at that governs the sessions is 1302, which is called regular session and talks about regular sessions. There are other laws that do talk about the extraordinary session that you're now talking about. The one in particular that gives some authority to the legislature to call an extraordinary session is 196.497 sub 10 sub C. That's where I see that the legislature can do that, and I see that the governor, by the Constitution, can call a special session. So other than those provisions, where is the law that tells us that you can call this extraordinary session? And if you wanted such a law, why can't the legislature pass one?
Well, Your Honor, the legislature did in fact pass subsection 3, which allows for the scheduling of the entire session throughout the biennial period. And if Your Honor has any doubt as to the meaning of subsection 3 with regard to regular sessions and extraordinary sessions, the very same legislature, within a month of passing subsection 3, adopted a joint resolution scheduling the entire biennial period.
Right, it's a work schedule for regular sessions. I get that.
Your Honor, no. That joint resolution, and I would ask Your Honor to carefully look at that joint resolution. It's on page Appendix 34 through 36. Specifically provides that the legislature has a regular session, and within that regular session, it can turn any floor period, into committee period, into a floor period titled a regular session. So the legislature clearly, in the very legislature that enacted subsection 3, understood itself, under that subsection, to have the authority to turn a committee period into a floor period, which happens to be called an extraordinary session.
Which isn't a law, so you're saying basically the legislature has the ability to not do what the Constitution is telling that it must do, which is sessions scheduled by law.
Subsection 3 is a law. Everyone recognizes
Subsection
that 1302, subsection 3 is a law. The very legislature that enacted subsection 3 adopted a joint resolution within a month of that. That same resolution authorizes the turning a committee period into a floor period. The only way Your Honor could accept my friend's submission is to conclude that the legislature in 1971 intended to render its own joint schedule unlawful under subsection 3. I would submit that that is an entirely implausible reading.
Well, I'm looking at the Constitution, and that's why when you also started with the 4 decades worth of what's been done, that doesn't, if it's constitutional, it's constitutional. If it's not, it's not.
Right,
So-
Your Honor, the Constitution provides, the terms are very important, shall meet at the seat of government at such times as provided by law. It doesn't say with the titles given in various laws, with the internal requirements of certain law, at such time as provided by law. Everybody here agrees that the legislature met at such time as provided by law in January 2017.
Right.
The only other question the Constitution allows this court to ask is, when did that meeting end? Not did floor periods get titled?
Right, so I understand your argument if you are, the one that you are making, well, you're making 2, but the one you're really focusing on is that this session never ended.
Well, right, Your Honor.
So that would really render superfluous the language "at such time as shall be provided," because if it never ended, why
Your
would you
Honor.
need to have that language? Along with numerous other statutes that were cited in the opposing brief that really call into question this idea that every single day that they were in session.
Your Honor, the notion that every single day the legislature is in session before final adjournment, legislature is meeting, comes directly from this court's decisions in Damon and Thompson. I don't think there's any way to read those decisions except to say that when the houses of the legislature are in recess, but the legislature has not dissolved itself, it is still meeting. The very question in Thompson, there was a several-month recess, and the governor said, well, I can make recess appointments at this time because the legislature is not in session. This court emphatically rejected that and said when the houses are in recess, the legislature is still in session. And this court, and I understand that was a statutory case, but this court specifically looked at Article 4, Section 11 to illuminate that statute. When the legislature has understandably relied upon this court's decision in Damon and Thompson to organize its internal affairs, and I think it would be quite remarkable at this late day to now basically adopt the position that lost in Thompson, which is that when the House of the Legislature are in recess, then the legislature itself is not in session. That issue has been settled in this court, I would submit, for almost 90 years, but at least for 50.
Counsel, I'm mindful of Article 4, Section 8 of the Constitution, which provides that each House may determine the rules of its own proceedings.
Yes, Your Honor.
I want to make sure that I understand appropriately what sources of authority we may look at in resolving this question. So obviously we start with Article 4, Section 11, where it tells us that the legislature is to meet as provided by law. And by law, I understand that we all agree that refers to statutes, correct?
That's right, Your Honor.
So we look at Section 13.02, and that's the only statutory section that we need to reference to answer this question. Is that right?
Right. Reference the question of when did the legislature meet. It's certainly not true that the Constitution makes every aspect of 1302 constitutional.
Correct, yes. But as we're going through the filtering process, we start with the Constitution. It tells us to look at the law. So we look at the law, we find their statutes, and in the statutes we find Section 1302.
That's right, Your Honor.
Right, okay. So now Section 1302 refers to a joint resolution in sub 3. And now we can look at the joint resolution to see what that provides for, correct?
That's correct, Your Honor.
Okay, because under Section 13.02 sub 3, by referring to that joint resolution, that then becomes part of the law.
That's correct, Your Honor.
Okay, just want to make sure how far down the road we can look.
That's right, Your Honor. And then any other matters about what the legislature titles its sessions, what internal rules it applies to the sessions are beyond this court's jurisdictional authority under Ozan and Stitt. And I think it's quite important to understand my friend's arguments. They concede that every floor period that is authorized nowhere but in the joint resolution, the ones that are pre-scheduled, are entirely permissible. Their submission is that the floor periods that are convened pursuant to the joint resolution, but are not prescheduled, are not permissible. But there are only two differences between the floor periods that they say are permissible and those they say are not permissible. One is the title, and two is certain rules, internal legislative rules under subsection 8 that govern what subjects can be considered. Now, I think it would be quite a remarkable violation of interbranch comity to knock out numerous laws and a 4-decade-old practice, because the legislature here happened to title this non-prescheduled floor period an extraordinary session rather than a non-prescheduled floor period as part of the regular session. Nothing in Article 4, Section 11 has a titling requirement, and nothing in Section 1302 has a titling requirement. Putting the titling issue aside, the only other difference that plaintiffs can point to is the fact that in a non-prescheduled floor period, it is subject limited. It can only be considered, only certain subjects can be considered. But of course, nothing in Article 4, Section 11, or in Section 1302 requires that every floor period allow for open consideration of everything. In fact, certain floor periods in Joint Resolution 1 are subject limited themselves. If your honors look at that joint resolution, there's a limited business floor period, under which the houses of the legislature reconcile bills that if they pass two bills that have different language, they will, during that floor period, just reconcile. And there's also a veto review floor period. So those are subject limited floor periods. And yet nobody, I would submit, argues that those are somehow unconstitutional or ultra vires. Now, Justice Dell referenced the fact that our argument somehow has an impact on other statutes, but in fact there are no statutes under which our argument is problematic. One of the statutes that my friends raised is the statute about when lobbyists can donate. As we explained in our reply brief, that statute operates just fine. The language in that statute clearly refers to the last pre-scheduled floor period. Until the last pre-scheduled floor period, lobbyists can't donate. Once the last pre-scheduled floor period ends, lobbyists can start donating, and if a non-pre-scheduled floor period is called an extraordinary session, then the lobbyist prohibition applies again. They also refer to the legislative pay statute, but they refer to the wrong statute. The relevant statute is 13-121, which says that legislators are paid throughout the year, which of course is entirely consistent with our understanding and with Damon's and Thompson's, that there is a continuous session. Because if my friends were correct that the legislature dissolved itself in March, then how could the legislators keep getting paid? The provision they do point to on legislative pay is 13-123. But of course, that provision specifically provides that the legislatures are getting per diems only when they are in Madison. So it sets up perfectly well. The legislatures get paid throughout the biennial session, which happens throughout the 2-year biennium under the joint resolution and under historical practice. And if they're actually in Madison, they get per diems. So that deals with that issue. They also referred to the statute that talks about continuances of courts. This issue about whether the continuous session required continuances of courts was before the Court of Appeals in the Chaval case. What the Court of Appeals decided was that because of the difficulties of saying there would have to be continuance at any point, we're going to interpret that statute as a matter of constitutional avoidance to say that continuances are not mandatory, they're subject to the court's discretion. So there's absolutely no problem on that section. So there are, in fact, no statutes under which there would be a problem under our submission, but there would be significant problems under their submission. Most primarily, there are several statutes, including the lobbyist statute, that specifically refer to extraordinary sessions. And I think it's an incredibly parsimonious and inaccurate understanding of those numerous statutes.
Counsel, if I may.
Yes, Your Honor.
Thank you. In some ways, this case is very, very complicated. In some ways, it seems there's a simple avenue. As I understand your argument, it really boils down to that once you convene, it's a 2-year continuous session.
Unless the legislature decides to dissolve itself, which is what used to happen for most of the state's history. You know, in 1951, the legislature dissolved itself after 6 months. That could happen again.
And your argument then means that an extraordinary session is merely part of the regular session. Is that correct?
I do think that if this court finds the regular session label to be relevant, that's the way this court should decide this issue. And I think that my friend who represents the governor would very much appreciate that resolution, I would think, because
well, I don't care what they appreciate. What I mean, I do with all due respect to everyone, but it just makes no sense to me that a extraordinary session is a regular session. There are statutes that refer to extraordinary sessions. There are statutes that refer to special sessions and the Constitution also. So if it's all regular sessions, why do you have these others denominated as a special session? A special session, and I would say to a fourth grader, is special regular? And a fourth grader would say, no, I'm special, I'm not regular, right? So you're saying special is regular.
Well, Your Honor, I think Your Honor is referring to extraordinary, not special. Special is what's called by the governor. Now, I would say...
I know Article 5, and I know the power given to the governor. I'm saying in fourth grade playground nomenclature, special isn't regular. And they wouldn't use the word nomenclature.
Your Honor, we're talking about here, not the playground, we're talking about the relationship between the branches. The only thing that Your Honor has said to differentiate what Your Honor is referring to as a regular floor period, an extraordinary floor period, is the name. The legislature could easily retitle the extraordinary session a non-prescheduled floor period within the regular session without changing any of the substance. When we're talking about the relationship of the branches, it would be quite remarkable, I would think, for the courts to say, legislature, what you've been doing for 45 years, and all these statutes are thrown out. The reason? You used the wrong name. I think as a matter of inter-branch respect and comedy between the branches, that kind of ruling should not be entertained.
Well, aren't we not talking about using a name? We're talking about the meaning of words. Not just a label, but what a meaning is. And when you read this language, this is all about regular sessions. And how can regular sessions be extraordinary sessions? It is not a label. And when you talk about, first of all, throwing it all out, that's not necessarily what we have to do, as you're well aware. And second of all, you've got a really easy fix, don't you? The legislature can pass a statute talking about these extraordinary sessions, a law pursuant to the Constitution, so that they can meet pursuant to the Constitution by law.
Your Honor, the legislature passed a law in 1971. It was subsection 3.
Okay.
Within a month of that law, Your Honor.
Right. Subsection 3 does not say anything about extraordinary sessions. It talks about a work schedule. Was this day in the work schedule? I don't think so. No, I actually know so. It was not. It was an extraordinary session.
Nothing in the word schedule requires every single day to be fixed and denominated such that it can't be. If Your Honor wants to know what the 1971 legislature, the one that enacted subsection 3, thought, I would ask Your Honor to look at Appendix 35.
Okay.
Your Honor, if Your Honor wants to look at Appendix 35, what the legislature says is the regular session of the 1971 legislature shall run from January 71 to January 73. And then it will have floor periods, we'll have committee periods, and that regular session can turn a committee period into a floor period titled an extraordinary session. It was perhaps not the best title that could have been chosen, but it has no statutory relevance, and it certainly has no constitutional relevance, which is the only issue that this court has jurisdiction to consider under this court's decision in Ozan and Stitt.
Counsel, I want to return to the jurisdictional line, and I want to make sure that I'm drawing at the right place. So we can look at the terms of the joint resolution, but the extent of our jurisdiction would be to determine whether the legislature complied with the terms of the joint resolution. Is that right?
No, the extent of this court's jurisdiction is to determine whether the legislature complied with the terms of the Constitution.
Right, but here we're working our way down to the pointy part of all of this. We start with the constitutional provision shall meet according to law. The law relevant here is 1302. In 1302, we find the reference in sub 3 to the joint resolution. And eventually we get to the joint resolution, and that tells us about this meeting that the legislature had, right? So
I mean, that's one way to look at it. I would look at it, and that is a perfectly fine way to adjudicate this case, but I would look at it a little differently, Your Honor. The way I would look at it is the Constitution says meet at such times as provided by law. So I think that raises two questions. What time did the legislature meet? Did it convene at some times provided by law? Everyone agrees that the legislature met pursuant to 1302 in January 2017. The only other question I would submit Your Honors need to ask is, did that meeting end as a constitutional matter? And there, that answer is provided by Thompson and Damon, which is the legislature's constitutional meeting only ends when the legislature dissolves itself. Every other question in my submission in this case, whether things are titled regular session, whether they're subject matter limited, are completely outside the court's jurisdiction. That's the way that I would address this. But the way that you discussed it is also a permissible way to do it if Your Honor wants to go on.
Should we
If we do it your way, do we have to make a distinction between meeting and session?
If we do it my way, Your Honor, all Your Honors would have to do would be to reaffirm the holdings of this court's decision in Damon and Thompson that the legislature's constitutional meeting does not end until the legislature dissolves itself, until it ceases to exist.
That the meeting does not end or the session does not end?
The court's decision in Thompson dealt with a statute that used the words in session.
Yeah.
The court's decision in Thompson equated in session with Article 4, Section 11, and said that those were the same. So that's why this court in Thompson held that when the houses of the legislature stood in recess, the session continued, and they equated that with the constitutional meeting under Article 4, Section 11.
Thank you.
Should Article 4, Section 8 play any part in our analysis of the question presented?
Yes,
Your red light is on, so in order to be fair for both sides, you can just think about that question and perhaps talk about it in rebuttal.
I will, Your Honor. Thank you.
Okay, thank you.
Good morning. May it please the court. Jeff Mandel here on behalf of the plaintiffs' respondents. Before I begin, I would just like to note for the court that with me today are my colleague at Stafford, Kurt Samatic, and co-counsel from Protect Democracy, Dina El-Malawani. Also present with us today are all of the plaintiffs, the individual plaintiffs and representatives from each of the organizational plaintiffs.
Counsel, you are asking this court to rule that the Wisconsin legislature has been acting unconstitutionally for over 4 decades. How can that be? Don't you find it extraordinary that nobody has raised this issue before this court in over 4 decades?
I don't think it's extraordinary. We're talking about just under 4 decades. To be clear, we're talking about the first extraordinary session was in 1980. And as the legal scholars pointed out in their amicus brief, state constitutional law is, notwithstanding this court's and many wonderful members of the bar's significant efforts, frequently overlooked. And it often takes what the legal scholars call a catalyzing event to bring something to attention. It is the case that Article 4, Section 11 has been part of our Constitution, part of the compact between the people and their government since 1848.
And that compact says that the legislature shall meet at such time as provided by law, which both parties agree means statute. So doesn't that mean that the legislature can determine for itself when it meets?
I don't think so, Your Honor. I think that what it says
Who else enacts laws?
Well, the governor has a part in enacting laws, but let's put that aside for a second. What Article 4, Section 11 clearly means is that the legislature shall meet when the statutes authorize a meeting. That means it shall not meet at any other time, and we know that because of the unless clause.
And the statute says that the Joint Committee on Legislative Organization shall meet and develop a work schedule for the legislative session. So why can't that work schedule include extraordinary sessions?
Because there is nothing in any part of the statute or the Constitution that authorizes an extraordinary session. And Your Honor, just to be clear, what 13.02 sub 3 directs the Joint Committee on Legislative Organization to do is to develop a work schedule, but it does not require, the Joint Committee's work does not bind the legislature. It only applies if the legislature chooses to adopt it by joint resolution. There is no requirement in the statute that that adoption be made. There is no adverse consequence if they don't. What that work schedule does is provide a convenience so that when the legislature adjourns from day to day, instead of saying we're going to meet again on date certain, they can say we're adjourning pursuant to the work schedule. So we come back when the work schedule provides. That's all that it does. It certainly is not enough to allow the legislature, by including in there a line that says, well, we reserve the right to turn any day that we possibly want into some other kind of session that is nowhere else provided by law. It doesn't.
Are you arguing that floor periods then are constitutional, but extraordinary sessions are not constitutional?
Extraordinary sessions would be constitutional if they were provided by law. There is no law that provides for extraordinary sessions.
There's no law that provides for floor periods either. Has the legislature not been acting constitutionally in anything it's done?
No one is suggesting that, Justice Kelly.
I'm suggesting it. If you're going to say that an extraordinary session is unconstitutional because a statute does not provide, the legislature has been operating on floor periods. I don't see floor periods anywhere in Section 1302 either. So what's the difference?
The difference, Your Honor, is that the floor period is part of the regular session in the legislature.
Excuse me, how do you know that?
How do we know that?
Yes.
We know that because the legislature says so. We know that because...
Excuse me, where did the legislature say that a floor period is a part of a regular session?
Well, it said it a number of times, Justice Kelly.
Okay, give me one instance.
Well, I'd like to give you several.
Okay.
It said it when it amended the Article 4, Section 11 in 1968, and it provided the explanation to the people that...
I'm not interested in the explanation. It's not a part of the text.
Well,
I'm looking for text that says a floor period is something that's part of a regular session and nothing else. Do you have anything that says that?
That text, Your Honor, the best indication of that text is going to be the journals that clearly identify, and this court has always held that the legislative journal is determinative of what the legislature has done. The floor periods are all denominated part of the regular session, and the extraordinary sessions are denominated entirely separately. As we pointed out in our brief, Justice Kelly...
Hang on just a second. I want you to slow down here. So you're saying that, before we get to the journal, you're saying that an extraordinary session is unconstitutional because it's not provided for by law, correct?
Yes, Your Honor.
Okay, and by that you mean extraordinary session does not appear in a statute, yeah?
It is not at a time that is authorized by statute.
That's not my question. You're saying it's not by law because it does not appear in a statute.
We are saying that it is only valid constitutionally if it is at a time that is provided by statute. And 196.497...
No, hang on a second. Don't run away with me here. I'm going to get lost. So you got to help me out. So if it's your position that an extraordinary session is not lawful because it's not provided for in a statute, right? So if 1302 said you may meet in extraordinary session, you wouldn't have a problem with that, right?
That's correct, Your Honor.
Okay, now it doesn't say that, and so you do have a problem with it. What I'm suggesting to you is that I'm trying to find a limiting principle for your argument, because the statute doesn't mention floor periods either. So is there anywhere in a statute, because you are requiring that the meeting be provided by statute. So point me to a statute that says a floor period is part of a regular session, a statute.
Your Honor, I don't have such a statute, but I don't think that we're saying exactly the same thing about what the Constitution requires. The Constitution doesn't require a specific statute that authorizes the Constitution requires that they meet at a time that is provided by law.
Okay.
The work schedule addresses the regular session. It sets forth the floor periods of the regular session.
Okay,
no one has any problem with that.
All right, so now then, is it a question of taxonomy for you then? It's just a question of how we classify this.
Well,
Is that the problem?
It's not really a question of taxonomy, Your Honor. It is much more than that. Mr. Saitlin says the only thing that we care about is the name, but that simply isn't true. He also, as he acknowledges, there's a limited purpose versus a general purpose, but that is not the only distinction. The rules are different. An extraordinary session has always been treated by the legislature as different. And Mr. Saitlin wants this court to defer to the legislature out of comedy, but doesn't want this court to take seriously the legislature's own words and behavior that these are different things.
What about Article 4, Section 8? Should we look at that, where it talks about the legislature being able to set its own rules?
We should, Your Honor, but Article 4, Section 8 does not swallow Article 4, Section 11. Article 4, Section 8 says that when the legislature is meeting, once it's conducting its business, it gets to decide the rules of doing so. But Article 4, Section 11 clearly shows that the framers wanted something different for when the legislature should meet. Mr. Saitlin says—
Well, why would the legislature have power under Section 8 if it wasn't meeting? What would it be making rules about?
I'm not sure I understand, Your Honor.
I don't understand you either, so we're on the same page.
So, Chief Justice Roggensack, what I mean is that the legislature is empowered by Article 4, Section 8 to determine the rules of how it conducts its business when it's meeting. That doesn't, however, mean that it is empowered without any review to decide how and when it convenes to conduct that business.
How does that fit with our decision in Ozon? I think we relied a little bit on Article 4, Section 8 in that case.
Well, the court did, but actually Ozon is very helpful to the plaintiffs here, because in Ozon, there were two arguments, as I understand it. There was an argument that the legislature had violated the constitutional open meetings requirement and the statutory open meetings requirement. And even in this court's brief decision, if you look at it, the court quickly dispenses with the constitutional argument. It says, the fact that not everyone could fit into the chamber does not mean the doors weren't open. And even those who could not fit into the chamber had access to watch the proceedings, just as the students upstairs today, Your Honor. And therefore, there was no constitutional violation. The court then went on to hold that out of interbranch comedy, the courts do not review the legislature's compliance with a procedural statute. And that's exactly the distinction we're drawing here. The question is whether the legislature complied with the Constitution. We're not asking anyone to police a statute.
Is 1302 sub 3 a procedural statute?
Well, it is, Your Honor, but 13.02 sub 3 cannot swallow on its own either 13.02 sub 2, which is the only part of the statute that actually authorizes the legislature to meet and conduct business.
But certainly they deal with the same subject matter. We would never interpret part of a statute without understanding its relationship to the other parts of the same statute, Counsel.
Well, I agree with that, Your Honor, and I would say the same about the Constitution. So we can't read Article 4, Section 8 so broadly that Article 4, Section 11 has no meaning. The legislature here is trying to read Article 4, Section 11 entirely out of the Constitution, so that all it means
well, I think that they can both exist quite well together. They have for a number of years. I didn't interpret the argument of opposing counsel as trying to read it out of existence. I just think the interpretation is different than that which you put forward.
Well, I think, Your Honor, if we accept the legislature's submission here, Article 4, Section 11 simply makes sure that the legislature gavels itself to order initially at a time as shall be provided by law. That is contrary to the plain meaning of the text, which is a limitation on the legislature. It's true from the text. That's what that unless clause means. If it were true that what the framers intended was that the legislature hold an amorphous perpetual session during the term of the assembly, there wouldn't need to be that unless clause. It would say maybe also the governor could call a special session, but it says they only meet at this time unless there's a special session.
Well, actually, Counsel, it says it shall meet according to law.
It says they shall meet at a time as shall be provided by law, unless. The unless shows that the first part is a limitation. It expands the possibility.
Except, let me finish. So the provided by law language, that might presume that the legislature and the governor might agree that there will be a limitation on the amount of time that the legislature meets. But maybe the legislature and the governor decide you're just going to meet constantly. Anything in Article 4, Section 11 prohibit that from happening?
Your Honor, if the legislature were actually to decide that it were meeting constantly, that would be an interesting question. And whether it's constitutional, it certainly wouldn't accord with the understanding of the framers or even the people at the time they amended it in 1968.
But it would accord with the text, yes?
I think it probably would, but we don't need to decide that here, Your Honor.
Maybe we do because of this. So, provided by law, we go to 1302, and then we try to figure out whatever it is that the legislature meant by 1302. And if it is so, and if it is, as you say, broad and amorphous, well, the legislature has the authority to adopt a broad and amorphous theory about when it meets, doesn't it?
Well, certainly, Your Honor, but let's be clear. The only way the legislature can support its argument for this broad and amorphous interpretation is to ignore the text of the statute as a whole, to ignore the text of the Constitution, and to point the court toward a joint resolution that was passed a month prior. But legislative history is not part of interpreting a statute until we decide what the plain meaning is. We start with the words of the statute. The legislature is being very fast and loose with the words of the statute, the words of the Constitution, the words of this court. Mr. Saitlin said earlier that Damon, this court's decision in 1936, absolutely supports his view that the legislature is in perpetual session. And here's what it said. The legislature was not in session on that day being the day that the governor had returned his veto message, it having theretofore temporarily adjourned. There's not a perpetual session. What there is the power for the legislature to control its schedule within the regular session in the way that we laid out in our briefs. There's a distinction in Damon and Thompson between an adjournment of the legislature pursuant to Article 5, where the legislature ceases to exist, and the idea under Article 4 that the houses sometimes recess or temporarily adjourn. Those two things are distinct, and Damon makes that clear. Yet here the legislature wants to conflate them. And it is simply the only way to give full meaning to the text of the Constitution and the text of 13.02 and the text of the other statutes, as Justice Dallett was discussing, is to acknowledge that extraordinary sessions, as the legislature has always indicated, are different in kind from regular sessions. They are different things.
Counsel, let me see if I can get at it this direction. At page 6 of your brief, you say that when the legislature met in extraordinary session, quote, their decisions in ... violated Article 4, Section 11 because there was no law providing for the legislature to meet in December 2018.
No law, what? I didn't hear that.
Sure. No law providing for the legislature to meet in December 2018, right?
Correct.
Was there a law providing for the legislature to meet in March 2018?
There was, Your Honor.
What law was that?
It is 13.02 that authorizes a regular session. The regular session commenced pursuant to subdivision 2 of that statute in January of 2018, and then you follow the chain, as we explained in our brief, that each time the legislature finishes its daily meeting, it adjourns to another time. It adjourns to a date certain, or it adjourns pursuant to the work schedule. That's the law that allows that.
Well, okay. So I like your chain analogy, but I don't find that in the law. Where do we find authority for that?
Well, the chain analogy, Your Honor, really comes out of Damon and Thompson, where this court authorized the idea of temporary recesses and adjournments without an end to the legislature.
Right. But now you're switching from statutory authority to what we say, and what we say is not statute, right? So if the law requires that a meeting in December be authorized, then it must necessarily mean that the law must authorize a meeting in March. And what you're referring to get to March being authorized is what we've said in our opinions, not the law.
Well, Your Honor, look, the statute doesn't have to, we've never maintained, it's only the legislature in its reply brief that brings forward this strange argument that the legislature needs to authorize each day's session by statute, and if the governor didn't sign the statute, the legislature could never meet. No one's ever said that. There are background principles of law about how legislative meetings work. And the idea of adjourning to a date certain and picking up the meeting then is such a background principle that this court recognized in Damon and Thompson.
Yeah, and maybe we shouldn't have. Maybe we should have been paying attention to our jurisdictional limitation when the people of Wisconsin adopted Article 4, Section 8, that allows for the House to determine its rules of proceedings, right? So when the Joint Committee gets together to plan out its work schedule, that seems to be rules of its own proceedings, doesn't it?
Well, Your Honor, I would say two things. First, the Joint Committee is acting pursuant to statute. Second, to rule, so that's not necessarily acting just under the rules of its proceedings. And second, if we read if we read that authorization so broadly, the court will be reading out of the Wisconsin Constitution, out of the charter by which the people have limited the power given to the government, any kind of restriction in Article 4, Section 8. And I would refer the court, before it does something like that, to look very carefully at the historical sources that are in our brief and in the legal scholars, historians' brief, because it was extraordinarily clear and completely uncontested in this case. Mr. Saitlin conceded it expressly to Judge Neese in the circuit court that the purpose of Article 4, Section 11 was to limit how often the legislature met and how much it could do.
Right. Well, and I agree with you with that. I don't think there's any question that's why this was done. But what was actually done put in a great big potential door, right? So the Constitution says it shall meet as provided by law. And that allows the legislature and the governor to decide when and how often it's going to meet. And if they decide that they're going to meet for 2 years at a time, if they decide that they're going to delegate that authority to a joint committee to decide when they meet, the statute allows for that.
Well,
how do you get around that?
Let me say a couple of things about that, Justice Kelly. First of all, if the legislature wants to, we have taken the position in our briefing, if the legislature would like to pass and the governor would like to sign a law that authorizes extraordinary sessions, just like in 196.497, just like temporarily in 1987 Wisconsin Act 4, that would be fine and would pass constitutional muster. That hasn't happened here. We're still conflating, at bottom, even if I accept everything you've said and accept much of what Mr. Saitlin has said, we're still conflating regular sessions and extraordinary sessions, which simply are distinct, separate creatures.
Counsel,
All right, so let's say that the Joint Committee designated every single day during the 2-year session as being a floor period, and that from time to time they cancel floor periods and turn it into committee work days. Can they do that?
We've already covered that, Your Honor. I think it would be inconsistent with the original intent, but I do think it would probably be legal. But
Then how is that different from what they actually did?
Well,
because it seems to me that it's just the obverse, right? Instead of scheduling every day as a floor period and then changing them to committee work days.
I know your red light is on, and I asked opposing counsel to sit down when his red light was on. So you can briefly answer Justice Kelly's question, but I don't want you to go into anything else.
Understood.
Right.
Justice Kelly, it's radically different from what they did, because the joint resolution, if you look at it, and I'm looking at Appendix page 123 of the legislature's appendix, does not say that the session is every day of 2 years. It says the biennial session period. It says a unit of time lasts from January of 2017 to January 2019. It sets forward expressly when they may meet. And the other reason that it's radically different of what they actually did is your idea that that they're acting pursuant to that they're acting pursuant to this work schedule, and that makes everything okay, simply is not true under the facts. If one were to look at the journal, and we cite this in our brief, when they convened the extraordinary session, they did not reference the work schedule. They did not say, we're using JCLO's authority. They simply didn't. And so it's not authorized by the statute that governs JCLO. It's not authorized by the work schedule, even if the work schedule were law, which everyone here agrees that it's not. Thank you, Your Honor. For these reasons, we would ask that the stay be lifted, the injunction affirmed, in this case remanded with instructions to enter a declaratory judgment in favor of the plaintiffs.
Attorney Packard?
Thank you, Chief Justice, and may it please the court. I'm Tamara Packard. I represent the governor of the state of Wisconsin. The governor is represented here today by his chief and deputy chief legal counsels, and I'm also here with my colleagues Aaron Dumas and Beauregard Patterson. The people of the state have commanded the governor to see that the laws are faithfully executed. The laws of the state are faithfully executed. That is what we seek to do today, and our analysis shows that the legislature acted unconstitutionally by legislating in the extraordinary session in December of 2018. I would like to follow up the discussion about the plain text of both the Constitution and the statute to talk a little bit about the allocation of power in the Constitution as well as the historical context of the relevant constitutional provision and why these things also support the conclusion that the extraordinary session was unlawful. In 1848, the Wisconsin's founders were concerned with the tyranny of legislation. They distrusted legislative authority. The people sought to constrain the legislature by granting it only limited power in the Constitution. It designed it in order to, as the Supreme Court noted in 1860, for the Constitution to function as a limitation on the powers of the legislature. They imposed limitations on the form of bills. They limited whether and under what circumstances the legislature could pass private, special, or local bills. And most importantly here, they limited where, when, and how often the legislature could meet. Now, Professor G. Allen Tarr, who is cited in the briefs, explains that these restrictions arose in the 19th century in response to widespread legislative abuses. The framers meant that these restrictions further more open and deliberative process to prevent irregular meetings and to ensure notice to legislators and the public both to know when these meetings are happening so that we could avoid legislative overreach and so we could safeguard liberty. As the legal scholars further detailed in their brief, it was important for the people to know in advance when their representatives would meet so that they could consider, attend, petition, lobby, otherwise be apprised as to the activities of their representatives. They sought to prevent legal abuses, including these illegal, irregular convenings.
Counsel, I think that's all correct. My question is similar to your colleague. If the legislature passed a statute that said that the legislature shall meet for the entire 2 years without interruption, could it do that?
It might. That might meet the letter of the constitutional language. I don't think that it fits with
Would you
the
tell us
intent.
that we would have to find it unconstitutional if they did do that?
I think we'd have to look at the actual facts of that legislation.
What fact would be relevant to our consideration?
What would be relevant to the court's consideration, Your Honor, is whether that statute was actually designed to a constitutional command to articulate the time that the legislature shall meet.
Right. Well, the Constitution just says as provided by law.
Correct.
It just dumps it in the legislature's lap.
It dumps it on the legislature to set a time for the legislature to meet. And all three of those words are important. It doesn't just dump to the legislature the ability to just sort of say, well, we're going to get together for 2-year periods and we're going to do whatever we want whenever we want.
Well, and it might not be prudent to do that, but it might not be prudent to do that, but the Constitution just requires that they meet as provided by law. If the law that they pass is we're just going to meet, it's going to begin in the first day of the legislative session, it's not going to end until the next legislature is seated. That would be as provided by law, right?
If the legislature, for instance, were to pass a law that said we are going to meet on January 8th, 2019, and that's all that the law said, And then they were to say at the end of the meeting that day, we're going to get back together again next week. And at the end of that meeting, they said, okay, now we're going to get together again in 3 months. Then that is a continuous meeting. That's what they were doing in 1968.
Work with me on the hypothetical that I proposed. They pass a law that says we commence our meeting, say January 9, 2019, and we're going to continually meet until January 8, 2021. Could it do that?
I think there would be problems with the intent of the framers.
Counsel, I want to return to your constitutional discussion.
Yes.
And you made reference to the legal scholars brief.
Yes.
And it references on page 4 that since 1848, Article 4, Section 11 has been amended twice, but neither revision transferred extraordinary convening authority to the legislature. It also indicates that many states have now changed their constitution to give the legislature the authority to convene extraordinary sessions. And then it sums that up with saying, no other state, I'm reading from page 1, handles extraordinary sessions of the way that is being proposed until today and in this case. Is that really accurate? I mean, that what's being proposed here is so unique in the 50 states, and that other states have deigned that it is necessary to change their constitution to give express authority?
No other state has signed off, no other state court has agreed that this kind of process is allowed except when it was specifically authorized by the Constitution.
Well, our Constitution says as authorized according to law, right?
Correct.
Now, I know that the legislature previously has passed in 1302 sub 3M a law that authorizes an extraordinary session. That's referenced on page 40 and 41 of the brief of the League of Women Voters. Is there any other time the legislature has authorized by statute an extraordinary session that you're aware of?
There are the two instances set a time for an extraordinary session to deal with the budget question. And that was to occur immediately prior to or prior to the start of the next annual session. The other has to do with this nuclear waste disposal compact issue. And those were both passed by the legislature, signed by the governor, and published into law. But those are the only two times the statutes have explicitly authorized extraordinary sessions. Now, I will say that there is another source for authority for extraordinary sessions, and that is the governor's authority under Article 5. Article 5, Section 4 says that the governor has the power to convene the legislature on extraordinary occasions, and that dovetails with the provision in Article 4, Section 11 about how the legislature can be convened either by the legislature, as the legislature provides in law, or by the governor in special session. Those are the two ways that the legislature can meet currently. And immediately after they passed Article 4, Section 11, saying that the meetings had to be provided by law, the legislature went and passed a law back in 1848 that said, this is when our single annual meeting will occur. It's a regular session. And that was it. Now, the people have always limited the legislature to meeting only at times provided by law, unless the governor calls a special or extraordinary session. Through Article 5, Section 4, and Article 4, Section 11, it is the governor who, at least up until today, holds the exclusive power to call the legislature into special or extraordinary session. The governor did not call the December 2018 extraordinary session. Everyone agrees with that. The governor could have, but he did not. And the legislature lacked the authority to do that. Now, the legislature argues, and I believe—
your red light is on.
Then I will ask that the court affirm the circuit court's ruling, vacate the stay.
Very good. Thank you so much. Rebecca?
Thank you, Your Honor. I would like to begin by answering your question about Article 4, Section 8.
Thank you.
Article 4, Section 8 settles this case. I think we all heard counsel for plaintiffs tie himself up in knots trying to explain what the constitutional difference is between a floor period, which is mentioned nowhere but a Section 3 joint resolution schedule, and an extraordinary session. That is because the only difference between those is the name and the internal operating procedure under which those are held. Both the name that the legislature gives to a floor period and the internal operating procedures, including what it publishes in its journals, are core issues of internal legislative procedure under Article 4, Section 8. It cannot possibly be the case that the legislature's actions would have been constitutional if it had simply named and printed in its journals that this is a non-prescheduled floor period as part of the regular session, and instead of extraordinary session. And I think once kind of all the rhetoric and is kind of cut through, that really is what their case is all about, is that we used the wrong name.
As opposed to you didn't pass a law. You want to focus on the names versus the laws that were actually passed, because the legislature could have passed a law, right?
Your Honor, we passed—
Called extraordinary sessions.
We passed subsection 3, which authorizes us to schedule our entire biennial period.
Under the regular work session.
Within a month, within the same month, we passed a joint schedule that is identical in every relevant respect to this one. The only way Your Honors could adopt plaintiff's position would be to conclude that the legislature, within a month, intended to render its own schedule illegal. I would submit that that position is frankly absurd, and that this court should reverse the circuit court and make clear that this case should be dismissed. Thank you, Your Honors.
Okay, thank you very much. This is really a fascinating case, so I appreciate you all bringing it forward to us. This is our last oral argument for the term. And before we all leave, I would like you all to join me in thanking Justice Shirley Abrahamson, who has provided services to the state of Wisconsin since 1976 on this court. Please join me in thanking Justice Shirley.
As the justice on this court who has served the longest with my colleague, Justice Abrahamson, I just would like to say also a few words. I think that Justice Abrahamson's career, and everyone here knows, has been one that is remarkable. She started this journey on this court in 1976, and just imagine at that time, not only was she the only woman justice and the first woman justice on the Wisconsin Supreme Court, she was the only woman judge in the state, the entire state of Wisconsin in 1976 when she started this journey. And of course, along the way, I kind of smile when I think of all of the honors and accolades that she has received. Perhaps it shows a limitation of my experience, but I know of no other person who has received more honorary degrees from colleges and universities throughout this country, and I understand she's getting one this Saturday also, than Shirley Abrahamson. I remember reading a few years ago a 2-volume encyclopedia entitled The 100 Greatest Judges in All of U.S. History. I looked quickly for Bradley, as in Ann Walsh Bradley, and it was not to be found. And this list, this 2-volume encyclopedia, was compiled with the votes and the nominations and the process of historians, legal historians, political scientists, and members of the legal community nationwide. And among this list of legal luminaries, you find, of course, John Marshall, the first Supreme Court Justice, Chief Justice of the United States. You find people like Oliver Wendell Holmes, or our own, Wisconsin's own, William Rehnquist. And at the top of that list is Shirley Abrahamson, listed among the top 100 jurists of all U.S. history. Now, lest she think too much of herself, she's at the top of the list, of course, because of her last name, beginning with A. So we have much to thank her about for her many years of service, the longest serving justice in the history of the state of Wisconsin. And I think the people of this state have much to be thankful for her tireless efforts in serving the people of this state. I know that for many years she has said to me that when she sits here, she's standing up for the people of Wisconsin. So thank you on behalf of myself,
Thank
I
you,
think the
Ann.
entire court, and the people of this state, Shirley.
Very well said, Justice Bradley. We are adjourned.